Mr. Jared Brown, thank you so much for coming on to Letters from a Contrarian.
Thanks for having me.
To get started, could you tell us a bit about what you do and what your thoughts were on the restrictions when they first came into play?
I'm a litigator, commercial litigator in Toronto. I run a small shop prosecuting and litigating basically disputes of all kinds for corporate clients. And in terms of the restrictions, it was right away. Immediately. Well, first up, I was actually in Florida during March break of 2020, and I was watching from afar what was happening in Canada. And it was a very different experience to what we were seeing in Florida at the time. So, the great paper panic, if I recall, was occurring in Canada, and restaurants were closing down, and people were basically hunkering down. We were not seeing that in Florida. I was there with my family and my children, and restaurants were still open. People are still hitting the beach. There was just a different level of I guess it's fear. There really wasn't any in Florida, and it was completely palpable in Toronto and in Canada. Obviously, we came home as everybody ought to have done. We did what we were supposed to do. Came home, and immediately was plunged into a little bit of a dystopia in terms of culture shock from what we've been experiencing in Florida, and then what we came home to in Toronto. And my initial reaction, I think, at first I understood people voluntarily doing the things that we ought to do to keep each other safe and to observe public health restrictions and requirements. But it was when they began to mandate the stay-at-home order, the lockdown, if you will. I think it was around March 20th, they closed the schools, something like that. I immediately detected that this is not where we want to be. I was completely opposed to it immediately. I saw a very bad thing starting up, and that was my initial reaction.
Okay. And so how did you, as a commercial litigator, come to represent 7 churches and 3 individuals in Manitoba?
Interesting. So the applicants in that case, which you've just mentioned, were represented by the Justice Center for Constitutional Freedoms, which is a law firm essentially that litigates constitutional disputes and constitutional issues. And they've been doing it for many, many years, and they're very, very good at it. I think they're located in Calgary. They approached me and asked if I would be able to assist lead counsel, who was Alison Pejovich, as well as co-counsel Jay Cameron from the JCCF, if I could assist them in this charter challenge. And specifically, they wanted me to cross-examine the medical experts, the expert evidence that was being put up by the province of Manitoba. And although it is a little very outside my day-to-day practice, I don't do constitutional law. I was excited. To take the opportunity. There's certainly some skills transference between what I do every day in commercial disputes in court and examining experts in court and transferring that to a subject area, which obviously I'm passionate about in the moment.
Okay. What was their case against the Manitoba government?
So the case is quite simple. I mean, they represented both churches as well as an individual protester who had claimed that their charter rights had been infringed by the public health restrictions that were brought in by the province of Manitoba purportedly in response to the COVID-19 pandemic. In both those instances, what you have with the churches is obviously their charter rights to religion being infringed. They allege that not only their right of assembly, but also to be treated equally and not to be discriminated against were infringed by the restrictions, which prevented them from gathering in church. And the other, with the protester, it was that he wasn't able to gather and assemble in a public place and actually protest the restrictions themselves. So that's the claim that was brought. These are fundamental charter rights. These restrictions prevented people from protesting in public, gathering in their private homes, and also gathering in the religious sense for communal worship. And so these particular applicants were prepared to step up and to test those public health restrictions.
And Who were the so of course, in a charter case, as I understand them, um, someone or an individual or an organization sues the government, takes them to court, and then it's on the government to defend themselves when um, there's been proof that the charter rights have been violated. I don't think anyone denies that the rights have been violated. What was the government's defense?
So you're absolutely right. They conceded the infringement of the charter rights at the outset at a preliminary stage. In fact, before I became involved in the application, there was a hearing to that extent, and the province of Manitoba said, "Yep, we are infringing fundamental freedoms and rights." And so what it then moves to is what's called the Section 1 analysis. And so all the charter rights are subject to infringement by government that can be demonstrably justified in a free and democratic society. And there's a thing called the Oakes test, which determines whether or not notwithstanding that you're infringing the charter, whether or not it can be justified in the context of what we're looking at. And so that is what the hearing was at the beginning of May in Manitoba before the Chief Justice, was whether or not the government, province of Manitoba, could say that these are justified, could demonstrably justify these things in a free and democratic society. And so that essentially was what the hearing was supposed to be about.
Okay, and so there are a couple of steps to the Oakes test. One is to establish an objective. I'm forgetting the steps. Could you go through them and then also say which ones the government tried their best to defend or hinge their case on?
Well, so I'm not a constitutional law expert, and so I'm not going to get the argument entirely right, but nor the Oakes test itself, to be candid. But basically, they have to have a stated objective. The infringements have to minimally impair the charter right. There's a variety of other issues that basically they want to make sure that there's a pressing and substantial concern that's been stated, that's recognized, and that the resulting infringement that the government deploys is proportionate to that pressing substantial concern, that it only goes as far as it needs to go, that type of thing. And if they satisfy those elements of the Oakes test, then the court will allow the government to infringe on basic freedoms and rights.
Who were the experts that you cross-examined?
So the province of Manitoba relied upon the evidence of a Dr. Kindrachuk, who is an infectious disease expert in Manitoba, Jason Kindrachuk, who put forward substantial expert opinion evidence by way of affidavit, attesting to what I would say is the pressing and substantial concern that is COVID, as well as the testing regime that they've adopted within Manitoba to surveil the disease as well as to respond to it. And so that was Kindrachuk. And then there was Lynn Siracusa, who essentially is the head of the hospital system in Manitoba, the healthcare system, looks at capacity issues, things like that. There was a Dr. Carla Lipkey, who is, I believe, the head epidemiologist for public health in Manitoba. There was, I'm going to get this wrong here. They brought in a former chief epidemiologist from Manitoba, who gave expert evidence about the public health response and why it was justified. I can't think of his name at this point. I apologize. There was also the Chief Public Officer of Health of Manitoba, Dr. Brent Roussin. He was on the stand for a full day, attesting to why they did the things they did, the pressing substantial concern. And then also there was Dr. Jason Bullard, who runs the lab, the CADAM lab in Manitoba, and he attested to and gave opinion evidence about the testing regime and how they detect COVID and surveil it.
Got you. What information came to light during the cross-examinations that most Canadians don't know about?
There were a couple of things. Three main things, I think, that appeared to get some traction outside of the Court of Queen's Bench in Manitoba. And one of them was that the that there was the statements that Manitoba made to the public to justify lockdowns that they had engaged in November and through the Christmas season of last year were purportedly in response to threats to their ICU and hospital bed capacity in the province. And essentially what came out of the cross-examinations was that the number of hospital beds and the number of ICU beds in the province was actually substantially more than what the public had been led to believe. And so at one point, I think they said that there were 72 ICU beds in the province, and that there were 129 patients in the ICU, and therefore we must lock down and effectively cancel Christmas. And there was evidence that came out that no, there was in fact approximately 175 ICU beds at that time, and the possibility to expand those to 220. Not to say that the hospital system wasn't under pressure. It clearly was, and I'm not saying that would have been an easy feat, but it seemed to be something that the general public in Manitoba had not been aware of, that they were not over capacity, if you will, that the hospital system had responded, that people like Miss Siracusa had moved heaven and earth in order to find the capacity that was needed so that there was no denial of care, no triage of patients. Another big element that came out, and this was the cross-examination of Dr. Bullard, as well as some of the other experts, because of course the applicants put up expert evidence as well. But Dr. Bullard acknowledged that the PCR testing regime, which is the backbone of the COVID public health response, it's how they determine who is a case of COVID, it's how they surveil it, it's how they target their public health response, that the PCR test is being used in a way that it's not typically used in. And what I mean by that is the PCR test is able to detect fragments of viral RNA in the back of somebody's throat with a swab. What it doesn't detect is whether or not those are intact viral fragments, meaning are they infectious? Do they have the ability to infect? They don't detect whether or not the person themselves is infected or whether or not it's simply colonized the back of their nose. And so the PCR test itself, there was a lot that came out about that meant possibly many of most, if not of the positive tests of what we call COVID-19 in the province of Manitoba may not have been infectious, may not have been infected, could have been infected up to 100 days previous to the test itself. And yet, when you have a positive test, you're then thrown into the public health response. You have to isolate. All your close contacts are contacted. They have to isolate. All of that infrastructure suddenly descends upon you, and you're treated as a case of COVID, when in reality, they've detected the presence of the viral fragment of SARS-CoV-2. COVID-19 is the disease. That means symptoms. And in any event, that was a big issue about whether or not we have a pressing and substantial concern from a constitutional perspective. If the numbers that you see every day on the news are not people who are infected, infectious, perhaps the magnitude of the problem is not being accurately captured. The final thing that came out in the examinations in the hearing that I'm not sure people were aware of is that there really wasn't a lot of creativity in terms of the public health response. Manitoba, to a great extent, justified their measures on the basis that everyone else was doing it. That we saw what was happening in China, New York, and Italy, and therefore we're doing it. And of course, they're doing it across Canada in the same way. And so we're no different. We're just doing, what everyone else is doing, and therefore it's justified. And I think a lot of people expected to see more. Certainly I did. That there wasn't much of a cost benefit, or what the public health people call a harms benefit analysis undertaken. Not to say that they did not give any evidence of undertaking that, but anyone who watched the hearing would have thought that the evidence provided of actually conducting a harms benefit analysis on these things in the Manitoba context was lacking. I was shocked. I was shocked at how little was provided. Effectively, what happened was Dr. Roussin on the stand said, "Yes, I considered the harms of lockdown, and therefore, don't worry. We looked at that." And of course, when I'm in the midst of the hearing, I'm saying, well, hold on a second. We've got all this data, all this evidence of studying the problem of COVID, the pressing and substantial concern that is COVID, and yet we had next to nothing about what the downstream harms of the lockdowns may be. There was, in fact, one document that may have alluded to these harms that was produced in the entire proceeding by the Manitoba, and it talked about some eye-popping numbers around increases in overdose deaths and violent crime and self-harm and poisonings that had happened post-lockdown, and that was it. There was nothing else. There was nothing else, and I think a lot of people were expecting more. That if you're going to implement unprecedented measures, maybe a more robust harms-benefit analysis would have been expected.
That's very sad to hear. How strong of a defense do you think everyone else was doing it, so that's why we did it too, is in the court?
I think it depends on the point in time that you're at. So in the early days, we have to absolutely look outward and elsewhere. As this pathogen was finding its way around the globe, I think we need to and expect our public health people to look elsewhere to see the type of response, to learn about this particular pathogen and who it impacts and how it impacts. That was all very good things. And in fact, in the early stages, when Canada began to plunge itself into lockdown, there might have been a great justification for it. We just don't know. However, we're now a year and a bit down the road and we're using the same policy. At some point during the last 14 months, I would have expected a made in Canada response. I would have expected, with all of the peer-reviewed data and studies that have come out about this whole thing. I mean, it's easily the most studied pathogen, I would say, historically, in a short period of time. Some of our experts said that there is just a fountainhead gushing with peer-reviewed literature about this thing and about the policy response to it. Well, the policy response hasn't changed. We've learned substantially more about this thing than we knew in March of last year, but we're doing the same thing over and over and over again. And that's the disappointing part. So that argument of, well, we just did what everyone else did, I put more weight in that argument in the early days, in the early stages, March 2020. But I'd even say by the end of April 2020, beginning of May 2020, I don't think that's much of a justification what then followed.
That sounds similar to what David Redmond said a couple of episodes ago, where we had data already coming in from China, from Italy, on who was most vulnerable to COVID-19, and yet we still failed to protect them here in Canada. It's quite sad that we haven't changed anything in the last year of COVID policy. Did the government have the actual legal authority to bring in the restrictions that they brought in?
I'm going to say yes. Okay, so I'm going to say yes. Our Charter of Rights and Freedoms are subject to Section 1. Demonstrably justified infringements in a free and democratic society. So yes, none of our rights are unfortunately guaranteed. However, I'm going to say that if you're going to introduce what are unprecedented measures, I suggest, in the history of the world, in free and democratic societies, that your justification analysis, your Section 1 analysis that a court should be undertaking, must be significantly more robust than you would see in any other situation. And what I mean by that is, the Section 1 analysis says, can these be reasonably justified in a free and democratic society? These measures could be justified in Wuhan, China, for instance, in March 2020, welding people's doors shut and locking them in. Not a free and democratic society. We're different. And so while I have to say that, yes, I acknowledge that from a constitutional perspective, the government has an argument. It's got to be good. It's got to be good because it's a free and democratic society, Gene, and that means that any measures that take away or essentially eliminate those freedoms, such as forcing people to stay in their homes, you kind of lose the Section 1 analysis at that point, don't you? So yes, it candidly, I think they can do it, but I would have expected much more on the justification side.
Not just Section 1, though. Within the act, the Emergency Act itself, that gives the government the power to, quarantine people and stuff like that. I'm guessing that the people who wrote it must have put in something like a you can't violate charter freedoms when you are trying to protect people's health. I think that was the case with Ontario's restriction, based on a tweet I saw from Lisa Bildy. But is that the case in Manitoba, if you remember?
No, so as far as I know, the emergency orders themselves had nothing about let's do this weighing exercise. However, the Public Health Act in Manitoba does have, it's Section 3, and this is something the applicants relied on, was something that mirrored Section 1 of the Charter. And it said that public health measures ought not to be any more than can be reasonably justified in a free and democratic society. Just took a Section 1 analysis, plopped it into Section 3 of the Public Health Act. So they have to do this at two stages. And in fact, one of the experts that testified for the applicants is the former Chief Public Officer of Health, Dr. Joel Kettner. He was saying that these measures are not justified. He gave expert evidence to that effect. Well, he's the one who actually put that Section 3 of the Public Health Act into the legislation while he was the public health officer during SARS-1 and H1N1. He put that in there. And he tells us, he says that was put in there because there has to be a limit on what public health can do to people, healthy people, in a free and democratic society, or you're not in a free and democratic society. So,
okay. Did the government have a legal obligation to justify their restrictions? I started to change my mind about the restrictions in December of 2020, and I was a bit worried to not be able to find any opening plans back then, or why they were doing what they were doing, or from any of the provinces. Is that a obligation that governments only have when someone challenges them in court, or not?
Yes, unless somebody holds the government's feet to the flames with a constitutional charter challenge, there is no requirement that the government show its cards, so to speak, or justify its measures. However, good governance, the expectation that I would have in a free and democratic society is that my government would put those things out there, would justify the measures. And I think they would argue that they tried to do that. What I saw was not a justification exercise, but a fear exercise. I saw the use of fear in the public health realm in order to dictate compliance. And everything I've been told, including from Dr. Kettner, is you don't do that. Dr. Bhattacharya out of Stanford, who testified as well on behalf of the applicant, says you don't use fear in a public health response. And we're seeing why now. So they didn't do a justification. They did a fear-based, cower in your home, COVID's going to get you. And now they're having a hard time unwinding that. You're seeing that there are people demanding further and longer lockdowns. People who are not believing the government when the government says, if you're vaccinated, you're safe. Vaccine hesitancy is now an issue, and to a great extent, it's because they use fear as a tool of public health, not justification for their public health measures.
I want to go back to one of the three revelations you pointed out about, where the medical officer of health basically lied about how many emergency beds there were. This is something that I also think is not very good to do to the public, where you lie in order to get them to do something that they otherwise wouldn't do if you were to tell them the truth. So, for example, telling them that masks don't actually help you, or don't actually save you from COVID-19 or prevent you from spreading it. They did this in early 2020 so that people wouldn't run and take masks. They were doing this to get masks to the people who needed it the most, doctors and nurses. Do you think that lying to the public like that is a good long-term strategy?
I'm going to be very careful here and suggest to you that the witness didn't lie. Okay, so when they made a statement about what their ICU capacity was, and it turns out that there actually was this opportunity for further capacity, I'm not going to go so far as to say lie. They were above their normal capacity limits. Do I think that it's a good idea to be less than forthright and candid? No, clearly I don't. I think we look to our government people our people in government to be transparent, to be candid with us. And the reason is that when you live, and I keep saying this, in a free and democratic society, what you're doing is you want to give people the information and the transparency to be able to make their own risk assessments for their own individual lives. We are all free individuals. We have liberty and autonomy within the system, but it relies upon transparency with our leadership. It relies upon us being provided with the best evidence and being candid with us, so that we can then exercise our autonomy and liberty in a way that we're comfortable with, in terms of ensuring that our risk profile to, for instance, a foreign pathogen like COVID, that we're managing that risk ourselves. But when they stop being transparent with us, when they're not giving us all the information, for instance, that the healthcare system has this ability to scale up, okay, at much cost to the people within the system, and money and stress and anxiety to healthcare workers and all that. But yes, I acknowledge that. But we have the ability to scale it up. And for instance, in Manitoba, they have the ability to almost double hospital beds by opening closed wards and things like that. By not telling the public that you have that, you're not equipping the public to then assess their own risk, to then, act as free and autonomous individuals within the system. Basically, government's not trusting us. And so they had to scare us to do what they wanted us to do. And I just think that that's a bad way of approaching things, especially in the public health sphere.
Okay. Were medical officers of health supposed to have the power and the role that they currently have?
They have it. So I'm going to say that they have it. I don't know whether they should. I mean, I disagree that they should. I think our elected leadership should be ultimately responsible. In fact, there was an interesting moment in the hearing with Dr. Brent Roussin, the Chief Public Officer of Health from Manitoba, was on the stand. One line in his affidavit said that public health decisions should be made by the public health professionals, or the Chief Public Officer of Health. And I asked him, I think it was the last question, you'd agree with me, though, that our elected leadership should be making these types of decisions? And he says, oh, yes, of course. But that affidavit, that line in the affidavit, and even the way he had to say, of course, we are being governed by scientists, experts, public health officials, not by our elected leadership, which means that the typical accountability mechanisms are not in place. So the Chief Public Officer of Health is not accountable to the populace in the same way that the Premier, in this case Pallister, is accountable to the electorate. If there's a bad decision made by the Chief Public Officer of Health, yes, they can get fired, but there's no greater accountability to the electorate. And it scares me. We're a free and democratic society. That means that the democratic process is where the accountability usually resides. And right now, these public officers of health are operating outside of that accountability mechanism. And I'm not sure everybody's comfortable with that, because I certainly am not.
One of the sad things to see is that rights and freedoms seem to have so little value. They don't seem to be thought of seriously, and other things seem to take priority, like public health. That's understandable to an extent, but it seems like we're getting out of this pandemic pretty quickly, and we don't have gulag camps. We have hotel quarantines that will probably end, but that's just a very small minority. This is a very big question, but are you able to give how would you defend rights and freedoms to someone who was skeptical of them, who might have said, oh, actually, we should have gone down harder for the whole time, and they're dismissible?
It's essentially, once you give that inch, you can't get it back. The freedom is hard won and hard fought for, but the elimination of rights is easy. The stroke of a pen takes rights away. Freedom is usually fought through bloody rebellion. And so because of that one-way ratchet, if you will, you have to be much more careful when you authorize an intrusion on your rights, when you acquiesce in an intrusion on your rights, than you would with an expansion of your rights. And so my argument is that blood has been spilled in order to obtain the freedoms that we have. That's usually how freedom is protected. It's usually how it's won. It's not our history is not one of freedom and liberty. We are living arguably in the freest and period in world history, but it wasn't the natural state of being. And so this unnatural state of tyranny and authoritarianism is always knocking at the door. It's always there, and it's always ready to take away your rights. And it's a very easy thing to do, as we've just seen in the last year in Canada. So, I mean, one thing you did say, you said that you think that rights and freedoms are increasingly, I guess, threatened. And I would say only certain ones are. The equality rights jurisprudence is expanding quickly, and it seems to have a fire under it that means that it's going to burn brightly. And for a long time, equality rights are going to be things that are properly protected and expanded. It's the other ones. It's the basic ones. It's the freedom of expression. It's the 2A rights. Freedom of assembly. Those things are really in trouble right now, and it seems that the courts are creating different classes of rights, charter values, things like that seem to favor certain rights over others. And right now, we're seeing the greatest threat to civil liberties, I think, in Canadian history going on right now in the name of public health. And it's been shocking just how many lawyers, people in my profession, don't care. They think it's the right thing to do.
How much discretion do you think the courts will give governments over their violation of rights and freedoms? And do you think that the courts are the proper avenue to check governments and their violations of these rights and freedoms?
So the courts have given great discretion to governments in all the court challenges that have been brought on different elements of the lockdowns in different provinces. The challengers are not meeting with success whatsoever. There has not been any sort of widespread success in the courts in rolling back what I'll call the lockdowns or the public health restrictions. The courts have, for lack of a better word, been very deferential to the government in this instance, and been respectful of the government and giving them a wide field of latitude to operate in the public health space. And to a great extent, it's because the courts are just as terrified as the rest of the populace about the pressing and substantial concern that is COVID. Interesting, that's not so in the United States. The United States jurisprudence, and a lot of it that we actually refer to in Manitoba, is finding that no, this is not a justification for infringing fundamental rights like freedom of religion and assembly. And so applicants like our applicants in Manitoba, the applicants in the US that are similarly placed, have actually met with success in the courts. And I think that just speaks to our conceptions of freedom, our conceptions of liberty and rights being different from our American counterparts, and how much weight you put into them. I mean, if we were going after charter rights, I mean, and so those are supposed to be sort of on a higher level than Best Buy's or Costco's right to operate its business. Like, your right to assemble in church should be up here. And what's happening is Costco and Best Buy are allowed to operate. People are allowed to show up and line up for hours in line at Costco, yet the charter protected right is shut down. And in the US, they use that example and they say, that's not right. That's not right. If you can open a Costco and do it in a safe way, then you arguably should be looking at your charter or constitutionally protected rights more closely and not infringing them so freely.
Mm. Okay. You talked a bit earlier about how other lawyers seem to be quite okay with the restrictions, not really being very considerate about the rights and liberties that are being curtailed. What feedback have you received from them, just from being someone who has disagreed with the restrictions since near the beginning of them, as well as someone who has defended the churches and the individuals in court?
Oh, I've been attacked on social media, especially early March 2020. I thought that it was preposterous that the government would turn on and off the economy, and the resultant harm that would be caused to people, that could somehow be justified in any sort of free society. I was immediately attacked. You're killing grandma. We're not going to give you a ventilator when you get sick. That was a good one. And a lot of this came from not only those who would be sort of on a different end of the political spectrum than me, but it also came from people that were more closely aligned to me. People were scared. People thought, this is the least we can do. We're all in it together. And like I said, early days, I think we all agreed with that. Let's do our thing. Let's wash our hands. Let's keep our distance. Let's not assemble in great numbers, that type of thing. But when it became shut down the economy, just blunt instrument, like everybody, you're closed, you're on the unemployment rolls. I couldn't stand for that. I couldn't imagine that that would ever be justified in Canada, and or even like a rational policy response. And I was attacked for it. I would say that now, a year and a bit later, where we're still doing the same thing like Groundhog Day, now there's been sort of a migration, and now I think there's a few lawyers, those in the legal profession, that are saying, okay, an emergency by its definition is something that's time limited and short. It's an extraordinary time that requires extraordinary measures. Well, if it becomes 14 months of emergency, maybe it's not an emergency. Maybe it's something else. Maybe there's a different word for that. And I'm not going to say new normal, but it's, and so a lot of lawyers, I think, are beginning to recognize where I was a year ago, that maybe now it's not the way to go. But I'm disappointed. There are a lot of those lawyers who litigate for rights, and particularly the equality rights space, and they've just been completely silent. In fact, they're the ones who are calling the loudest for more, harsher, and faster lockdowns. And that's been disappointing, because those are our constitutional law experts right now. Because of the jurisprudence over the last few years, that's where it's been focused. And yet they're completely on the side of government in this instance. And so it's left to some of us, like commercial litigators, to have to step into the space and assist, some of the other constitutional experts that in doing what we need to do to at least call the government to account.
How did you deal with the pushback from other people, like we won't give you a ventilator when you're sick? And how do you deal with the disappointment from seeing so many people not in support of all constitutional rights, like the liberty ones and the negative ones?
Well, you have to be the lone voice in the wilderness for a while. I mean, I'm not going to say I'm alone. There are, smarter people than I, obviously, that can enunciate the counter argument on these things. I think of Bruce Party, Lisa Bilby. There's people out there that can enunciate the argument, but you have to be confident in your principles and confident in your position. That no, the lockdown is the experiment. The free society is the norm. When we have pandemics, and we've had them before, we didn't lock down. And so right now, the lockdown's the experiment, and those who are doing the experiment, advocating for it, should be the ones who show their cards, who justify it. And so, it was hard. It was hard. I mean, I even have family members that disagree with me on my position. They think I'm killing grandma. That's not easy. But I guess, in the beginning, I thought, I'm just going to put it out there. This is the way I think. I'm not seeing a lot of this out there, but I believe this, and I'm going to just stick to it. I then did wind it back. Once I had made the case and done it for a period of time early on, I did roll it back, because I realized that it was just causing conflict. I was basically putting a stick in people's eyes, and that didn't want to hear it, that were scared, and that people were dying. Clearly, COVID's a deadly disease, and there's a lot of death and suffering going on. And I just thought, I made the point, and I stepped back. However, obviously, with this Manitoba Charter Challenge last month, I've gotten back into it, and I've gotten, I want people to realize that, if you could justify this thing in March 2020, try and do it now in May 2021. Try and do it 6 months from now. It's a different thing. But I am going to wind it down. It creates unnecessary conflict for sure.
Okay, so I guess the rule behind it is that if you stand apart from the crowd with an opinion, and all it is doing, or most of what it is doing, is leading to more conflict where people are not open to change their minds, then you should probably step it back once you've shared what you've thought.
I think it's make the position, enunciate the position, do it in the venues that you think you'll be heard, and once you're satisfied that you've done that, you don't need to keep beating the drum. There's other ways. And so, for instance, me agreeing to come in and assist Allison and Jay and the JCCF on this hearing was me putting my money where my mouth is. Okay, so I've done I've laid the ideological groundwork. I've done the air game, the media game of what my position is. And I could just sit back and say, I'm a Twitter warrior. But the pressure was building on me to do something about it. And when the opportunity came, even though it's a completely foreign environment for me, constitutional litigation, I didn't feel comfortable just sitting on the sidelines. When you get tapped on the shoulder, you got to do it. And it was, there was some stress and anxiety associated with doing it. but it was the right thing to do. So there's an escalation, and you've got to follow your principles. You can't just sit back and tweet madly. And thankfully, I had the opportunity to do something about it, and I feel good that I did it. I feel good that I didn't just become a keyboard warrior. I used my litigation skills in a way that I think was getting behind my principles, and I think was for the greater good. So yeah, you got to get out there. You got to stake a position on things, and of course you're not going to offend anybody if you never take a position in life. So it's expected I'm going to offend people. Hopefully you do it in a minimally impairing way.
Okay, and so you're lucky because you get to actually take governments to court as a lawyer. What about the average citizen who doesn't have this information? How would you recommend they stand up against the restrictions if they don't like them? And how can they help people like you and other organizations fighting for liberty?
There's a couple ways. The most obvious one is to let your elected leaders know that this is not acceptable. Let your elected leaders know that you're no longer fearful of the pathogen, that you're prepared to accept some level of risk, and therefore the paternalistic attitude that is coming from government is no longer welcome. And you do that by contacting your MPs, MPPs. These are provincial things, so MPPs. Polling data shows that there's strong support for these measures. Well, unless that support changes, unless the pollsters are hearing something different, we're going to get more of the same. The next one is there's actually a dearth of people willing to step forward to be applicants on charter challenges. So to a great extent, charter challenges are not brought by the clients themselves. It's brought by lawyers who know how to do it and know it has to be done. And then they go about and find clients that are willing to step forward. And there's actually a shortage of them. There's actually a shortage of very few. And so more people willing to step forward. And the final element is putting your money towards causes that help, advocacy organizations, the JCCF. There's also the Canadian Constitutional Foundation, CCF, that's doing fantastic work. A bunch of lawyers there that are on the forefront of this stuff. Civil liberties organizations, a little quieter on this stuff, but you put your money towards those places and equip them to go off and make these arguments. I think it makes for healthy democracy.
Okay, and you said there's a dearth of people who are coming forward to help lawyers in constitutional challenges. I'm presuming that's because there's a cost to the individual person, whether it's like risk to your name or actual legal costs. Is there?
So there's the risk of legal costs at the end of the proceeding are actually quite low. If you're engaging in public interest litigation, which is what this stuff is, you rarely see a situation where you have a cost order against you. And also, my understanding is the Crown rarely pursues them if the person is unsuccessful. But there is risk there; it does exist. I think it's more the risk of character assassination. I'll give you an example. In our application, one of the applicants, one of them was cross-examined, and essentially what the cross-examination came down to was a bit of character assassination. It was a public shaming, and it was showing images and videos of this person not complying with the public health orders, not wearing a mask at a protest, standing beside people, and then one was a church service where people weren't abiding by the public health restrictions. That it takes a certain kind of person to stand up to that and say, I don't care that you're doing this, that you're trying to show me as a scofflaw, or that I'm not looking after my fellow man and things like that. And that's the problem, is there's a risk that you're exposing yourself to that type of treatment in a very public forum. So that's to a great extent, that's why people don't step forward. But it's also just like, who cares? I'm sitting at home, I'm watching Netflix, I'm zooming into work every day. That's the majority of Canadians. There's also a huge number who don't have that right and are suffering greatly. We're not going to get into that. But people are just complacent. They think that their rights will be given back to them shortly. In fact, a lot of lawyers thought that as well. There's a lot of lawyers who may have considered bringing a constitutional challenge to this stuff, but thought, no, you know what? It's a limited thing. They're going to end it in a month. My case will become moot. Well, that didn't happen.
Okay. And do you have any other final thoughts?
Yeah, just quickly, I think that these measures hit us at a special time in our history. I think that you're seeing a rise in sort of safety culture, generally speaking, in society. And these public health measures would not have been accepted in previous generations the way they are in this generation. And I mean, this is just my own thesis. I know people like Jonathan Haidt in the coddling of the American mind talk about the rise of safety culture. And I think we're seeing that. We're seeing a very receptive audience to their rights and liberties being taken away in an unprecedented way. And I think so there's a deeper issue here than just a government overstepping something. You're actually seeing an audience of people who are motivated by fear, who are unwilling to accept any sort of risk, saying, yeah, bring it on. That's what scares me.
We have to raise our children better, basically. How can people reach you if they wanted to reach you?
I'm on Twitter at litigation guy, and I've got a website, brownlaw.ca. You can find all my coordinates there.
Thank you so much for coming on to Letters from a Contrarian.
Thank you.